And I want to talk a little bit more about this FISA court because it was big news this week that the FISA court admonished, to put it charitably, the FBI. Let me put it uncharitably. The FISA court, when you interpret the order, and I'll read it, I'm going to read extensive excerpts from it, basically said they can't trust the FBI after what the IG reported on anything. So this is the order that was declassified or publicly released on December 17th, 2019. And one of the nice things about having access to you through this format is there are no time constraints. When I go on Fox News, I've got 3 minutes. When I go on media, I've got 20 seconds. When I'm quoted in the newspaper, it's one quote. But we're able to get into the detail necessary for you to be educated about these big scandals that you don't get from even friendly media, simply because of the constraints of the format. So we've got this wonderful luxury of being able to talk at length about this issue in a way that I hope keeps your attention. This order responds to reports that personnel of the Federal Bureau of Investigation provided false information to the National Security Division of the Justice Department and withheld material information which was detrimental to the FBI's case in connection with 4 applications to the Foreign Intelligence Surveillance Court for authority to conduct electronic surveillance of a U.S. citizen named Carter Page. When FBI personnel mislead the National Security Division, the Justice Department, in the ways described above, they equally mislead the court. In order to appreciate the seriousness of this misconduct and its implications, it's useful to understand certain procedural and substantive requirements that apply to the government's conduct of electronic surveillance for foreign intelligence purposes. And this is why I encourage you to read court rulings and government documents like the IG report, because the level of detail helps you understand the corruption. And oftentimes people say, you know, how bad is it? Well, if you think it's bad based on the news reports, they never really get into just how bad it is when you dive deep into how bad it is. And this court's order, however weak ultimately it is, and I'll talk about that, dives in deeply as to why this FISA Gate scandal is so detrimental to the rule of law and deserves severe investigation, mainly a criminal investigation. The crimes that were committed are legion. Title I of the Foreign Intelligence Surveillance Act, FISA, governs such electronic surveillance. It requires the government to apply for and receive an order from the court approving a proposed electronic surveillance. When deciding whether to grant such an application, a FISA court judge must determine, among other things, whether it provides probable cause to believe that the proposed surveillance target is a foreign power or an agent of a foreign power. Those terms are defined by FISA, the Foreign Intelligence Surveillance Act. A finding of probable cause to believe that a U.S. citizen or other United States person as defined is an agent of a foreign power cannot be solely based on activities protected by the First Amendment. Did you hear that? So if you're targeting someone because you don't like Trump, that's prohibited by law. And you can bet that's what was going on. The court didn't just cite that for yuck's sake. An electronic surveillance application must be made by a federal officer in writing upon oath of affirmation, citing the law. When it is the FBI that seeks to conduct a surveillance, the federal officer who makes the application is a federal FBI agent who swears to the facts in the application. The Foreign Intelligence Surveillance Court judge makes the required probable cause determination on the basis of the facts submitted by the applicant. And that's highlighted and that's emphasized, it's italicized, emphasis added by the court. A FISA judge may require the applicant to furnish such other information as may be necessary to make the determination required by law. These statutory provisions reflect the reality that in the first instance, this is the applicant's agency, the FBI in this case, that possesses information relevant to the probable cause determination, as well as means to potentially acquire additional information. Notwithstanding that the FISA court assesses probable cause based on the information provided by the applicant, Congress intended the pre-surveillance judicial warrant procedure under FISA, and particularly the judge's probable cause findings, to provide an external check on executive branch decisions to conduct surveillance in order to protect the Fourth Amendment rights of U.S. persons. So it goes on. So the court says they needed to provide this background, and this is what they wanted to say after they provide this and some additional background. So I'm not reading the whole page. On December 9th, 2019, the government filed with the FISA court public and classified versions of the OIG report. The OIG report describes in detail the preparation of the 4 applications for electronic surveillance of Mr. Page. It documents troubling instances in which the FBI personnel provided information to the National Security Division, which is the Justice Department legal team that talks to the court, which was unsupported or contradicted by information in their possession. It also describes several instances in which the FBI personnel withheld from the National Security Division in their possession, which was detrimental. Wait, let me start over on that one. It also describes several instances in which FBI personnel withheld from the National Security Division information in their possession which was detrimental to their case for believing that Mr. Page was acting as an agent of a foreign power. In addition, while the 4th electronic surveillance application, which by the way was signed by Rod Rosenstein, for Mr. Page was being prepared, an attorney for the FBI in the FBI's Office of General Counsel engaged in conduct that apparently was intended to mislead the FBI agent who ultimately swore to the facts in the application about whether Mr. Page had been a source of another government agency. The information about the OGC's attorney's conduct in the OIG report is consistent with classified submission made to the FISA court by the government in October of 2019 and November 27, 2019. Because the conduct of the OGC attorney gave rise to serious concerns about the accuracy and completeness of the information provided in the FISA court in any manner in which the OGC attorney was involved, the court ordered the government on December 5th, and I'll get to that order, which was just released today, to, among other things, provide certain information addressing those concerns. So what is this court talking about here? They're talking about that lawyer in the FBI, the anti-Trump fanatic, who took a document email from, I think, his CIA contact that confirmed that Carter Page was a friendly for the CIA and an asset, and turned it upside down by changing it and saying he wasn't a contact. They're trying to tell the court that Carter Page was a bad guy because he was working for a foreign government and he was an enemy of the people. And in fact, he was working for the people and a patriot. And they told the court otherwise. The FBI's handling of the Carter Page applications as portrayed in the IG report was antithetical to the heightened duty of candor described above. The frequency with which representations made by FBI personnel turned out to be unsupported and contradicted by information in their possession, and with which they withheld information detrimental to their case, calls into question whether information contained in other FBI applications is reliable. The FISC, the court, expects the government to provide complete and accurate information in every filing. They write every with emphasis. Without it, the court cannot properly ensure that the government conducts electronic surveillance for foreign intelligence purposes only when there is a sufficient factual basis. So pretty strong stuff, huh? This is where the court blows it. Therefore, the court orders that the government shall, no later than January 10th, 2020, informs the court in a sworn written submission of what it has done and plans to do, and to ensure that the statement of facts in each FBI application accurately and completely reflects information possessed by the FBI that is material to any issue presented by the application. So essentially they're saying, tell us what you're going to do to fix things going forward. No accountability. no orders that there's going to be a criminal contempt proceeding, no show cause order. The court has essentially said they can't trust the FBI on anything they're saying, which is in and of itself enough to, in my view, require the resignation of the FBI director, who, by the way, has sat on this information inexcusably for years. And anytime someone criticized the FBI, he defended the indefensible. And even today, he's still minimizing the misconduct by the FBI. But the courts, asleep at the switch. How do we know this? Judicial Watch. Because Judicial Watch wanted to find out, well, you know, we knew years ago, by the way, of this fraud on the courts. Devin Nunes alerted the courts to this years ago. Judicial Watch was raising questions about this in, what's this, August of 2018. And we asked the court for deposition of the transcripts of any hearings about these applications that were targeting the President of the United States. Again, they were targeting to Carter Page, but when you review the applications that were also obtained by Judicial Watch under the FOIA, heavily classified, which now should be unclassified, at least now the IG is, well, it should have been unclassified a long time ago. There's no excuse now that the IG report has disclosed what's in it. So were the hearings targeting Carter Page? It was all about getting Donald Trump, though. First the candidate, and then the President of the United States that had FISA warrants spying on the President's guy, Carter Page, or so they thought. So we said, are there hearings, hearing transcripts? And essentially the court told Congress, ignored our request largely, and they told Congress to ask the Justice Department. So we went and asked the Justice Department. And the Justice Department told us, and told the court in our FOIA lawsuit, because we had to sue to get a straight answer from this Justice Department, the Foreign Surveillance Court considered the Page warrant applications based upon written submissions and did not hold any hearings. You know, it's really easy to defraud a court if you don't call people in and ask them questions in person, don't you think? Now, I understand the court can't hold hearings on every FISA application it gets. And I understand why they defer and rely on the FBI and the Justice Department to be forthright. But it seems to me, if we're going to have the FISA court, as the court acknowledged in its order, that this process is designed to protect the Fourth Amendment rights of the individuals targeted, including, in this case, the President of the United States, they don't hold hearings on the most significant warrants probably the court has ever considered in its history. So where's the accountability for the court that was asleep at the switch? And as I say in this report, and in this extraordinary ruling, however strong it is, it highlights the criminal corruption at the FBI, the criminal contempt for court, in my view. They're not demanding anything in terms of any significant accountability. Just tell us what you'll do right in the future. And you know what? And we see that time and time again. The courts are way too deferential to the executive branch on substantial challenges like this. Now, it doesn't mean you don't get politically biased judges or judges who act outside their authority to target administration policies that they disagree with and pretend it's a legal disagreement or a constitutional disagreement when in fact it's just masking their political disagreement. I'm talking about the deference and the get out of jail free cards that are repeatedly given to government agencies and attorneys despite their misconduct and regularly misleading the courts. If Judicial Watch attorneys did what they did, what government attorneys are implicated in doing here, we would be hauled in, our attorneys would be hauled into court and they'd be put in jail immediately. Contempt of court, you can be put in jail immediately almost, until the contempt is cured. They could have hauled in the FBI director or another responsible official and put him in jail. Right out of the gate. Not forever, obviously. But that isn't going to happen. That isn't going to happen. So they're hoping it just passes. And if I were the president, I wouldn't let it pass. Because this FISA court is coming up for authorization again. Now, you know, in many ways, the president has the authority to spy on foreigners. The question is, what happens when Americans get caught up with foreigners? And how's that authority exercised? And the left put these courts in place to protect the people. But they don't care that Donald Trump is being targeted in a wild abuse of power by a court that rubber-stamped, as I say in our statement. I said this in October of 2018, by the way. No, August 2018. It is disturbing that the Foreign Intelligence Surveillance Courts rubber-stamped the Carter Page spy warrants and held not one hearing on these extraordinary requests to spy on the Trump team. Perhaps the court can now hold hearings on how justice was corrupted by material omissions that Hillary Clinton's campaign, the DNC, a conflicted Bruce Orr, a compromised Christopher Steele, and anti-Trumper Peter Strzok were all behind the intelligence used to persuade the courts to approve the FISA warrants that targeted the Trump team. And finally, they issue an order, because they couldn't avoid the truth after the OIG report, December, years after they were warned. And this earlier December ruling on the lawyer highlights the attorney's involvement in this, and the court wants to know what's going on. Identify all matters currently or previously before this court that involved the FBI attorney that has been referred for criminal prosecution now because of his messing around with the Trump warrants. And they want to know what's being done. Like I said, anyone else would have been hauled into court. They couldn't even call it a show cause order.
Thanks for tuning in. Be sure to subscribe to our YouTube channel to catch all the latest news from Judicial Watch.